Bruce, you must have something really good too.
Of course I do. It's Bruce Danielson, and I guess I'm here to entertain you too.
Representative Lester, you ready? Next bill that we're going to take then is House Bill 1204, enact revise certain provisions regarding power of attorney.
Thank you, Mr. Chairman, members of the committee, David Lust, House of Representatives, District 34. Mr. Chairman, I have an amendment to this bill. I'd like to circulate it.
Please do so.
I may have permission to speak to the bill and the amendment.
You have it.
Thank you. So House Bill 1204 is obviously a comprehensive bill, and there are people here who practice in this area extensively. I do not, and I will defer to them. But I will say this: I was a ULC commissioner for many years, and there are, as is the current chair, and there are many products of the ULC that I would not bring to South Dakota because they don't have much application. In any way, shape, or form, or minimal. This product, the Uniform Power of Attorney Act, is not one of those. I have spoken extensively with people who practice virtually exclusively in this area, and one comment I received from one of my law partners was basically, I'm kind of skeptical of these uniform acts a lot of times because I don't know that they have universal application or need, and he said, this product does have application in South Dakota, and there is a need for this. And I know he was on a subcommittee that scrubbed this bill from the South Dakota perspective, and he feels strongly that there is a good need, a strong need for this in South Dakota. So with that, I will step aside and let the experts in the field testify more about a little bit what the ULC is and what this law does.
Do you want us to go ahead and move this motion at this time?
That'd be great.
Okay, can we have somebody, Representative Dietrich moves and Representative Barthel seconds a motion to amend House Bill 1204. It's 1204 WA. All in favor say aye.
Aye.
Opposed, nay. Motion passes. So do we have any other proponents? You look familiar.
Thank you, Mr. Chair, Vice Chair. I'm Mark Feinstein. I sat in those chairs 2 years ago, and different on this side. And thank you for letting me come up here. Chair Stevens, Vice Chair Johns, members of the Judiciary Committee. As Representative Lust explained, Uniform Law Commission proposes laws and puts together laws through a painstaking multi-year process, and they go through and they take issues that happen all over the country in certain areas, and they digest the laws and take the betterment from various states. They have not only the commissioners, but they have stakeholders, observers from all areas, pro, con, all the groups that would or could be interested, like financial institutions and all that, coming to the table to put together these laws. And one of the reasons for uniformity, and especially in this area of the law, uniform power of attorneys, is the fact that we have a mobile society. A lot of our South Dakotans aren't here now because their air works a little warmer and a little bit more above zero than we have today. And to have power of attorney they may have if an issue arises, then they're going to be able to use that document in the state that's also approved this, and it will be acceptable and accepted for that purpose. And I think that the uniformity also, in our case, a lot of our statutes on the books were here at statehood time and revised in the early to mid 20th century, so it's time that we get up to the modern world and catch up with the 25 other states that have already enacted this uniform law. But more particularly, a power of attorney is a low-cost, flexible means of granting decision-making authority to another person. It strikes a balance between protection and convenience, and that's what this act in particular does. I want to go directly to skip way down to like section 24, where it talks about, section 24 talks about how the default provisions of this law work. In other words, if it works very well in areas like real estate, and that, where if you just say my agent has the authority to do what I would have done, without saying anything different and contramanding that, it'll affect real estate. In other words, the agent of our attorney can execute deeds, can sign a mortgage on the property, can satisfy a mortgage on it. It covers banking provisions, and there's a laundry list of statutes, of sections that are particularly cover real estate, tangible property, stocks and bonds, that if nothing is said contrabanding, if somebody said, I don't want my agent to cover my stocks and bonds, they wouldn't, but otherwise, the agent would have the ability to buy and sell their stocks and bonds. They have the ability to operate a business. If you're a business owner and something happens, you're incapacitated for a while, your agent in the power of attorney has the ability to run and operate that business, so it keeps you going. Insurance and annuities and estates and trusts. More particular, I could cover section by section, but I think in the interest of time, you guys and everybody can review that, and I can say, accept the fact that these have been run through. I mean, they go from the definitions to when this law is effective and that. But some of the teeth in this legislation that we don't have, or that we barely have in our state. If you look at section 13, it really covers an agent's duties. An agent's duties, which are the teeth of what the responsibility of the principal or the agent is to his principal. And it's a fiduciary duty. And that, as those of us who went to law schools, it's the highest punctilio of an obligation to somebody. You have to do it with even more respect than you would to a partner or to a co-worker. You have to be utmost duty with this fiduciary duty and a duty of loyalty. It also addresses conflicts of interest, as long as it's done in the best interest, in good faith, and within the scope of the authority. Another major area of this bill is the judicial relief that's found in section 15. In an effort to combat financial abuse, this Power of Attorney Act authorizes a comprehensive list of persons entitled to petition a court through the terms of a power of attorney or review an agent's conduct. These persons are in the best position to detect or prevent fraud, but may lack standing otherwise to petition a court. And this includes banks, it includes financial institutions, it includes interested persons, and they can go forward and say, hey, there's a problem here. Also, the agent's liability in section 16 is covered, that if a person, if she violates provisions of the bill, the remedy is to repay, pay back. Section 19 addresses what happens if the person, the third person, the agent goes to ask somebody to accept the power of attorney and they refuse. Well, there's provisions that that person can refuse to accept it only in good faith if they know that there's a problem with it. They're not liable if they accept it and they have no actual knowledge, or in good faith don't have any knowledge that there's a fraud being committed. Fraud is fraud, and this act does not condone any kind of a fraud. But when but there's not a problem to not accept it, or to accept it. You're not going to be liable for any major problem. that occurs because of a fraud made by somebody else, unless, again, you know that that person committed that fraud. In my own practice, in fact, just yesterday, I had an issue where an insurance company did not want to accept the power of attorney, and the insurance company is in Wisconsin, and it's like, the problem is when you do this work, you may, instead of going to court to get a guardianship or conservatorship, which is court approved, you're able to do it a lot less expensively with a power of attorney. But this insurance company would not accept the power of attorney. Well, this act helps make it so they would have to, and they wouldn't be liable if there was if there was a fraud being committed and they did not know it. It just sort of makes it acceptable. I think there are other instances where somebody totally refuses to accept it for no good reason. This law prevents that from happening. And I could go on and on, talk again more section by section, but I'll stand by for questions and let other folks testify.
Thank you. Thank you. We have a couple more minutes left. Let's read proponents for House Bill 1204.
Thank you, Chair Stevens, members of the House Judiciary Committee. My name is Tom Simmons. I'm from Vermillion, South Dakota, and I'm an associate professor at the University of South Dakota School of Law. I also chair the South Dakota State Bar Committee, formed under the Real Property, Probate, and Trust section, to study this act and to scrub it line by line. I'm here this morning in my individual capacity as a concerned citizen. I have not been authorized to testify on House Bill 1204 on behalf of the South Dakota Board of Regents or the South Dakota State Bar Association either. My remarks reflect only my own views. I wanted to explain briefly the committee process that we undertook to review this act line by line. Our primary goal was to first ensure that it looked like it would advance the interests of South Dakotans who use powers of attorneys to allow individuals, typically family members, to manage their affairs in the event of an incapacity and avoid the public and expensive procedure that a guardianship or conservatorship would otherwise require. Secondly, our aim was to ensure that the work product of the Elder Abuse Task Force in 2016, which resulted in a number of protections for especially elderly individuals with dementia and incapacity, that those protections and decisions from that task force were left undisturbed. And the product that you see in front of you ensures that. There were a few tweaks within the Uniform Act to ensure that the existing state of the law in South Dakota carries forward, especially with regards to the product of the task force. A typical power of attorney that would be drafted by an individual like me when I was in private practice would undertake to list each and every power that the agent would be able to exercise. And my particular form or forms that I would use would run for at least 10 or 12 pages single-spaced in order to list each and every individual power. The overall structure of this act and the benefit to South Dakotans is that it replaces the need for a lengthy, dense, detailed recitation of powers with a statute and then a form in which the individual who's signing the power of attorney can check individual boxes. So there's some length, and the benefit is that the individual powers of attorney that people will sign would be shorter. Moreover, it would help individuals realize what powers they were conveying, because I'll be honest, a number of my clients would not be able to finish reading my work product of 12 pages. And even if they were, by the end, their eyes were glazing over, and they may not have understood every power that they were granting. There could have been a power buried within there that they weren't comfortable with, whether I drafted it or another attorney. In checking the boxes, individuals are more key to identify whether I want to, for example, grant the power to my agent to make gifts of my property. That's a big power, and it's one that I would discuss very carefully with my clients. The format of this power of attorney that's permitted under the Act would direct individuals' attention to the particular powers that they're granting. It would also allow uniformity with the kinds of powers of attorney that attorneys draft and better allow third parties, whether they're banks or buyers in a real estate transaction or financial institutions, to review whether an individual agent has or lacks a power in question. They would know exactly where to look. And individuals that migrate from other states with this same act would also benefit from the familiarity with the same format. This act is, I believe, now in half the states, and it's pending in 4, including us and the District of Columbia. Thank you.
Thank you very much. Any other proponents? We got about 1 minute left. And I'll bet you're good at that.
Mr. Chair, members of the committee, my name is Eric Nelson. I work for AAR from South Dakota, and I serve as a registered lobbyist. I'm here on behalf of our nearly 105,000 members from across the state to ask you to support House Bill 1204. Powers of attorneys are essential tools for delegating authority to others to handle financial matters in many situations, including a potential decision-making incapacity. We feel that this bill has a significant impact. We feel that this bill further addresses financial exploitation in our state. Initially, we've been talking about a lot in recent years, and we ask you to support it. Thank you.
Thank you very much, Mr. Nelson. Any other proponents for House Bill 1204? Seeing none, then I'd ask for any of the proponents to House Bill 1204.
Good morning, Mr. Chairman and committee members. Isaac Latterall, representing District 6. I have a dear friend and constituent who was not able to be here in person today to testify, and I want to read a statement that she gave me. My name is Tanya Knudsen, and I live in Sioux Falls, South Dakota. My mother will be 97 on February 24 this month. I won't be able to live with her for this birthday. I don't even know where she is at. She was taken from me by a family member and placed somewhere. I have been her power of attorney for many years, but this changed when the family member took her to an attorney. Mom has dementia and gets confused very easily. As such, she is also easily talked into things, able to be manipulated by unscrupulous people. I looked after her for close to 25 years as she was able to live on her own with minimal help. I would take her to doctor appointments and to help get her the things that she needed. She once fell in her home and broke her ankle. While recovering, she was very confused, and I realized she could no longer be completely on her own. My husband and I bought a larger home and moved her in with us for 5 years. My sister and her husband constantly caused difficulties, and would become angry if I took Mom shopping. They felt she had everything she needed, and it was a waste to let her shop. I disagreed and ignored them. In a moment of weakness, I asked my sister's husband to assist with Mom's bank accounts. I felt he would see I was being honestly transparent. In the 5th year she was living with me and my husband, I had some health issues, and like many caregivers, I needed some help caring for her. What I was looking for was help with the daily physical demands of bathing and cooking and dressing her. Bathing, cooking for her, and dressing her. They used this opportunity to take her out for a visit and took her to an attorney, to then Mom's new power of attorney. She was convinced by them we were not spending her money wisely and she needed to come live with them. It was reported that they promised her she would be with them and not in a nursing home. I have not seen her for 3 years. They refused to let me visit her. I do not even know where my mom is. All I know is they have placed her in a nursing home. 1204 has no protections for my mother. This bill would allow what happened to Mom to be acceptable. Please stop 1204 from becoming law. We need to protect the person before we worry about the inheritance. Her husband also writes a letter which I will submit to the committee for you to read. I urge you to read it in the brevity of time. But I just wanted to add my own personal comments that I know this woman. She's a dear friend of mine. I know her mother. I know the situation, and what she's saying is true. The issue with 1204 is not that it's a bad bill in its entirety. It's that the power of attorney situation that it will create. A person is too easily able to switch a power of attorney. So I believe it creates an opportunity for elder abuse, and I just urge you to look at that, because if someone currently has a power of attorney with a person that is at risk for abuse, I believe it's important that there be a hearing where both sides are heard before that is switched. So that's what I'm asking you to consider. That's the issue that we see in this bill, and so I'll pass this letter out. It's dual-sided for your consideration. Thank you.
Thank you, Representative. Any other opponents to House Bill 1204?
Good morning, Mr. Chairman, members of the committee. My name is Brett Kennecke. I'm a lawyer from Pierre and a registered lobbyist for the South Dakota Bankers Association. The Bankers Association in the Washington, D.C. office has people that track uniform laws. And the Bankers Association in Washington has been and has communicated their opposition to this act since it was brought up in 2006, if I recall correctly. Mr. Nelson brought it to my attention last summer, so we took a look at it, looked at the scholarship coming out of Washington, and decided we couldn't get comfortable with some of the provisions either. I have an amendment here this morning that would resolve my objections. I will not be a supporter of this bill, but if you would put that on, it would resolve my objections. Briefly, I'll let you take a look at it. I'm looking at page 12 of the bill. In section 15. So over on line 5, you see there that it says that the court may be petitioned to construe a power of attorney or review the agent's conduct. So I don't know what that looks like. To me, it looks like a petition to review the agent's conduct. Is that turning the court into an investigative agency? I'm unsure as to what that means. That's problematic to me. In my understanding of the court system, you have to bring a specific bill, allege specific acts that have caused you a wrong, and then let the court decide what the remedy should be, should you prove those. And this is a new concept to me, review the agent's conduct. But then let's look at the list of people who can petition the court. Line 11, an individual who would qualify as a presumptive heir. We're conferring standing on somebody who thinks they're an heir to the person's estate. You get to go to court and have the conduct reviewed. Going down further, line 17, the principal's caregiver or another person that demonstrates sufficient interest in the principal's welfare. We've laughed in this committee in the past when I've said it's akin to giving mother-in-laws the right to start divorce actions. This isn't far from that, ladies and gentlemen. We're going to let somebody who demonstrates a sufficient interest, without guiding the court as to what that is, and let them go to court and ask that the agent's conduct be reviewed. I would submit to you that people want privacy and dignity in their affairs at the end of their lives. They want to have things handled by their family, and they want to maintain their dignity. And allowing somebody who thinks that they've got a sufficient interest to start a court action is far beyond the bounds of where my clients would want this to be. Going further down, I have difficulty with section, let me take a look here, I'm losing track of my iPad. I'm looking at page 16. A person that refuses to accept a power of attorney is subject to a court order mandating acceptance. I think that's probably fair. But then to pay the attorney's fees for the other side, bank tellers and bank officers are frequently asked to take a look at a power of attorney and handle the business of the affairs of their customer, and then when a third party comes in with the power of attorney and asks them to follow through on that, they are oftentimes, as we said in the task force that we discussed, in the best position to stop malfeasance and outright theft, and then to put them on their heels and say, well, you might be liable for attorney's fees if you stop a transaction from going through. That's the wrong message to send, in my view. Going further down, section 20, the principles of law and equity apply. I tried to look up and find out what I thought the committee, the Uniform Laws Committee, thought that meant, and I couldn't get comfortable with that. And finally, the section 22, I can't get comfortable with that language either on the remedies. If we're going to court to construe the power of attorney, then that ought to be the final word on it. We ought not hold open other actions to be available for somebody else. So I'm perfectly fine if 1204 gets changed with this amendment. I'm perfectly fine if 1204 dies. But this morning, we are not at all prepared to accept what 1204 says, and would ask for your consideration. Thank you.
Do we have any other opponents to House Bill 1204? We have 4 or 5 minutes left.
Thank you, Mr. Chairman, members of the committee. My name is Patrick Weber. I'm a policy advisor in Governor DeWright's office. We come today in opposition. While I will admit that I'm sure Mr. Feinstein and Mr. Simmons have forgotten more about power of attorney than I know, we come to you largely in the interest of stewardship of the code. What Mr. Feinstein, Mr. Simmons, and other proponents didn't outline are problems in today's code or problems with South Dakota's current power of attorney system. The closest that came to be articulated was Mr. Simmons outlining that he worries the current power of attorney is too long, and it makes it so that his clients, when reading it, their eyes glaze over and they don't understand it. He talked about a 12-page enumeration of those powers. We're talking about a 50-page bill where those powers will be enumerated. Mr. Simmons believes that a form or someone initials or checks to talk about the powers that they're giving up is the best way to do that. That is fully within his power as an attorney today. He can create that form. He can have a better system by which his clients are able to forego those power, to grant those powers of attorneys. What we didn't hear is that they can't do that today. At any point in this testimony, we didn't hear of a single example where the current power of attorney in South Dakota was insufficient or created problems in any way. These uniform acts can create long sections of code that make it more difficult for regular people to be able to understand their rights under the code, and can also make it more difficult for anyone to navigate the code. We would ask that you close this bill. The specific and substantial concerns that Mr. Kinnicky raised on behalf of the bankers are also major issues, but we specifically are worried about the code itself and this Uniform Act not being necessary for problems in South Dakota.
Do we have any other opponents to House Bill 1204? We have about 3 minutes left.
Mr. Chairman and members of the Judiciary Committee, thank you for this opportunity to speak on House Bill 1204. First, I believe in the model legislation.
Introduce yourself.
Oh, I'm sorry. I'm Bruce Danielson from Sioux Falls.
Okay.
First, I believe in the model legislation HB 1204 was supposed to be based on. However, the version before your committee this week only protects the commercial guardianship business at the expense of the person who may or may not have signed a power of attorney. I have witnessed and experienced this problem at its worst. This legislation as offered will only protect the abusers of those who needed assistance. When I recently asked the authors of this bill to consider modifications to the legislation, the answer was, well, you can sue if there's a problem. A person being abused usually does not have the ability to fight. In many states where this legislation has been introduced, it has created a professional guardianship industry stripping people of their rights, properties, and families. Frequently, what happens is the professionals strip the assets and then dump the carcass on the state Medicaid program. I've been an unpaid guardian, conservator, and power of attorney in multiple states for several people over the last 30 years. These people entrusted me to be their eyes, ears, and decision maker when they were most vulnerable. I've had to sit for hours over the course of years, and in some cases, to know their deepest thoughts, fears as they aged. I've been entrusted with their desires when the inevitable time comes to help them reach death with dignity. These are not easy decisions to make as a healthy person, and impossible to make for most when society does not want to help them in the way that they planned and documented. In each situation I've been part of, I spent the time to learn how they wanted my help. This legislation takes these most personal and private choices away from the person impacted, allows complete strangers to make choices while also benefiting from the misfortune. Frauds and deceptions can happen without the ability of the person's family or power of attorney to interfere. A person can be locked up in a facility their life controlled by strangers who have no interest other than the next check they receive until the assets are stripped. Do you know how I know this? I have a family member currently locked up in a house in a town she never wanted to live, with people she doesn't like, not being allowed to talk to her children without supervision. And we family members listen to her cry out for help during phone calls as she's asking us to stop the abuse without anybody being able to do so. This law as written will further decriminalize the entire process just described. Worse, there is no requirement to follow the standard and proven diagnostic procedures such as those outlined in DSM Diagnostic Standards Manual 4 before usurping a person's choices about life and property. Nor is there a procedure to remove oneself from the guardianship. I know you're busy with the work you do for South Dakota. If you have a chance to read the article at the link I'm enclosing and the article I enclosed with, you will see the abuses in the guardianship process which are already happening in South Dakota. Even the New Yorker magazine thinks this is government run amok in a recent article, How the Elderly Lose Their Rights. The decision of how we live and how we die is one of the most personal decisions a person ever makes. It's a very scary time. Please help us fix the system by first not making it worse by passing Uniform Power of Attorney Act, HB1204. The concept of bringing the process up to date is a good idea, but this legislation needs more work. I will volunteer to participate in a summer working group chartered to propose fixes that would better protect all parties and return a recommendation before next session. The bill as proposed devastates rights of personal choice and injects the state into matters of privacy where it has no business. Put safeguards in place first to protect the person before the inheritance. Thank you, Mr. Chairman, and the entire committee for allowing me to present my experiences and thoughts on this very important issue. And in the packet I've given you is a standard procedure that the medical industry is required to follow to make somebody incapacity. And I've presented that all to you so you can understand that there are medical professionals that do this, and they're very upset that nobody has consulted with them about how to make somebody declared impaired or incapacity. The other document I gave you in there is, the bill is 52 pages long. I was making comments on each line of each page as I found problems. I only got up to page 20 before I finally had to give up, because it just depressed me so bad to see such a horribly written bill. But I really do understand the need for correcting this process, and I hope you defeat this bill today so that we can go back to the drawing board and bring citizens like myself involved in the process. Thank you.
Thank you very much, Mr. Gaines. Do you have any other opponents? Seeing none. Representative Lust, do you want to do a rebuttal, or do you want to represent? Mr. Simmons, you want to do a brief rebuttal?
Thank you. Tom Simmons again. A couple clarification points. One is that this act does not relate to any healthcare decision-making authority. Those are covered by different statutes. This relates only to financial and property authority of an agent. There's separate statutes for healthcare decisions. Secondly, this isn't a guardianship bill. We do have a guardianship set of statutes, which include, for example, when a guardian or a conservator is acting, the ability of the court to review a guardian or a conservator's decisions and actions and determine whether they were appropriate or inappropriate. And that's exactly what the review statute for powers of attorney provides, a similar way in which a court could review whether an agent has acted improperly. There's also a provision within that review statute section that permits the individual who is the principal in an agent to simply ask the court to dismiss the action. They don't want it before the court. So long as the judge finds that that individual has capacity, the action is dismissed automatically. And so the concerns with a number of individuals who have standing to bring a concern before a court is moderated by the ability of the principal to have the matter dismissed upon request. The counsel for the Uniform Law Commissioners provided me with a statement that I'd like to read in connection with the bankers' concerns. This is Benjamin Orzecki. There's no current opposition to this Uniform Act from the American Bankers Association. There's only a 12-year-old letter from the chair of the drafting committee objecting to some provisions of the draft act. Some of the bankers suggested revisions from that 2006 letter were incorporated into the final version. Other suggestions were rejected. Now we have over 10 years experience with the Uniform Act in 25 states, and we can definitely state that none of the bankers' fears expressed in that letter have come to pass. Finally, insofar as potential liability for an individual third party to refuse to honor a power of attorney, beginning in 2006, we had a statute that put liability on third parties for wrongfully refusing to honor a power of attorney. And it exposes them to attorney's fees as well as damages if it's found that they wrongfully refuse to honor one. The analogous provision in this Uniform Act does not provide for an award of damages, only attorney's fees, and it provides for bankers or third parties that are dealing with an agent to request at the principal's expense certification that the power of attorney is valid, and they can rely on that. It also gives them a window of 7 days in which to request that. It actually provides them with greater leeway and opportunities to ensure that they're honoring a power of attorney that is in fact valid and effective. Thank you.
Thank you very much. We're in closed testimony. I open up to committee questions. Representative Johns.
Thank you. Well, Mr. Simmons is here. I'll just ask him a couple questions. Mr. Simmons, would you consider this bill to be a consumer-friendly bill?
I hadn't thought of it in that way, but I suppose so, yes. I believe that it helps consumers insofar as I believe it will probably reduce attorney's fees that attorneys charge for self-drafting these documents from scratch. And in that sense, I believe it's a consumer-friendly bill.
And would it make it more acceptable if I'm going to have a power of attorney and I want to utilize it, for example, in the state of Arizona, if that's a state that's already adopted the same type of legislation, would that make this much more universally acceptable?
Yes, consistent with kind of the idea behind the Uniform Commercial Code, uniformity greases the wheels of commerce, if you will. Absolutely.
And Section 19 was objected to. Was that your testimony that that's already covered by state statute, which you found at SDCL 59611?
Yes.
Thank you.
Any other questions by committee members? Seeing none, then I'll open up to committee discussion and/or action.
Mr. Chair.
Yes, Representative Jensen.
I think for me, there was enough question about some of the language in there that for me, I'm very uncomfortable with this. It's a very large bill. None of us have probably read it for word and understand it. And there is some, the opponent testimony was fairly compelling to me as far as the vagueness of some of the language. So I would, have you asked for action yet? I'm sorry.
Yes.
Okay, I would move 21st day.
Okay, we have a motion by Representative Jensen to move for the 41st day. Does he have a second? Representative Rosen?
Second.
Okay, do you have any discussion, Representative Jensen, or anybody? That motion?
Mr. Chair, no, not really, just what I said previously. Thank you.
Okay, Representative Johns?
Thank you. I have a substitute motion, do pass.
Okay, I have a motion by substitute motion for Representative Johns to pass. Do you have a second? Second by Representative Wismer. Discussion.
Well, these uniform laws do serve a very important purpose, and that is that we can have acceptance of these types of instruments throughout the country. And I daily draft powers of attorney, and mine get to be extremely long and complicated because of the way the law is now. This will allow me to just refer to various sections that my client can initial and make actually actions a lot easier.
easier. It's all part of your estate planning. There's no reason to be concerned about guardianships or conservatorships. Those are under the supervision of the court. They're treated totally different. But when you're doing estate planning, we regularly use these in our practices. And I think they're really a benefit to us. I'm not concerned about taking up pages in the code, frankly, for the simple reason that we've got over 500 bills that were submitted this year. If that was a concern, we would have probably killed a lot more than we have if we're going to worry about the number of pages in the code. So I recommend that you vote to pass this on to the floor. Thank you.
Representative Lust.
Thank you, Mr. Chairman. And members of the committee, I would urge your support of the bill. Listen, I know these uniform laws come and they're large and they're complex and they're dense. And I've been doing this for 10 years, and I think I probably had a uniform bill just about every one of those 10 years. And every time I pitch these on the floor, I just say they're in many respects, they're trust me bills. This is an area that even attorneys on this committee don't practice in. And I will submit to you that the process the ULC goes through is unbelievably comprehensive. All the players are involved. The bankers were involved in the drafting of this in 2006. And moreover, when it came to South Dakota to look for enactment, you've got a subcommittee of the bar who practice exclusively in this area, who have gone through and modified the ULC product to what you have today. So in that respect, in some respects, it is a trust me bill. It is a trust that I think has been earned by the Uniform Laws Commission and earned by the bar. Regarding the opponents, the bankers' opposition has just frankly not come to fruition. This bill has been enacted in 25 states. It's been around for 10 years. The doom and gloom you heard from them just frankly has not happened in any state. And there was no specific example that they'll cite because there is none they can cite. This has been studied by all sorts of groups in all sorts of different states. And it's frankly a little surprising that the bankers have opposed this because it helps them in more respects than it hurts them. And the governor's opposition, I mean, yeah, I get it's long. And I know it's nice for a governor to be able to say, hey, we've cut this much code and taken out this many words. And but that's not a compelling reason to oppose this bill. I mean, it's a comprehensive bill because it's a sensitive area that needs to be comprehensive. So mere length should not doom it to the 41st day. So I have full confidence in this bill, full confidence in the process, full confidence in the 25 states that have enacted it and have been working under it for 10 years, and I think South Dakota should do the same. Thank you.
Any other further discussion? I'll just say this, I agree, I don't think the governor's position on there is worthy of us not passing the bill. My objection of it is this, is that number one, I really don't hear that there's a problem, for number one. The second thing is we're really, my understanding of it is this, is you can either, and I prepare a lot of power of attorneys, and I must be missing pages 8 through 12 because mine's not that long as yours. But basically what you're saying is this, is from the attorney standpoint, you either prepare a long document and you hand it to your client and say, okay, here, read this, this is what you're giving up, this is the authority to do. And that's the responsibility of the client then to read it and say that's what they want. What this bill does is you check a box, but you got to go someplace else to look at what that box really means. And you have a lot of elderly people that come in, and I think that's asking a lot from that standpoint. And I think from a practical standpoint, that's really what we're doing, is it's kind of like with the probate code now. You can have it where if you're a personal representative, you automatically get these rights or responsibilities and powers that's in the code. But you have to go look at the code to see what those powers are. And I don't think a person should have to go to the second part of it. So it's kind of maybe a philosophical difference. So for that reason, I won't be supporting this bill. No. Any other further discussion, Representative Jensen?
Yes, thank you, Mr. Chair. And I mean absolutely no disrespect. I have all the respect for all the attorneys on the committee here. But using the example that the lawyers think it's okay, as a non-lawyer and a consumer and somebody that had a lot of trouble with my mother going through nursing home issues and some abuse issues, that isn't a good enough reason for me to vote for the bill. And again, I appreciate all the work the attorneys do. Representative Johns asked, is it a consumer-friendly bill? I'm not convinced that it is. I'm going to be voting against this. Thank you.
Any further discussion? Seeing none, then what we have in front of us is a do pass motion by Representative Johns and second by Representative Risner to pass, House Bill 1204, and act to revise certain provisions regarding power of attorneys. All those in favor of the do pass motion will vote yes. All those no or against it will vote no. Secretary will call the roll.
Representatives Lust.
Aye.
Dietrich.
Aye.
Barthel.
Aye.
Turbeville.
Aye.
Rosen. No. Reed.
No.
Peterson.
Aye.
Jensen.
No.
Kaiser.
No.
Bordeaux.
Aye.
Wismer. Aye. Johns.
Aye.
Stevens.
Go.
Eight and 5 nay.
House Bill 1204 receiving a majority vote and go to the House, House floor with a do pass.
Folks, anybody else want to entertain us?
We don't come up here to entertain you. We come up here to inform you.
What kind of morons run this outfit?